Yes.
Same apparently.
Very well, this is the ruling. There's some noise in the background. Registrar, someone's microphone is, I don't know whose microphone it is.
Taking care of your lordship.
Okay, yes, it's better now. Thank you. This is the ruling. This ruling is in respect of the motion on notice dated the 30th of April 2020, filed by the defendant, hereinafter referred to as Hesper. I hope everyone can hear me.
Yes, we can, your lordship. We can hear you loud and clear.
Well, we can.
Thank you. Seeking first an order striking out this suit for non-compliance with the pre-action protocol requirements of this court under its procedural rules and practice direction, and in the alternative, an order staying the proceedings pending arbitration. 2. The application is supported by an 11-paragraph affidavit deposed by Abiola Emeka Hassan and a written address dated 30th of April 2020. The claimant, Raspotech, opposed the grant of this application with a 13-paragraph counter affidavit deposed by Tolani Adeoye and a written address dated the 5th of May 2020. Hesper responded with the reply on points of law dated the 11th of May 2020, and the written addresses have been duly adopted in court today, the 25th of June 2020, by Counsel, who also offered oral arguments. The issues before the court are fairly straightforward and well distilled by the parties. The primary question which the court will determine is whether Raspotech complied with the pre-action protocol requirements under the rules of this court and the Expeditious Disposal of Civil Cases Pre-Action Protocol Practice Direction Number 2 of 2019, hereinafter referred to as the relevant practice directions, and if not, whether the non-compliance necessitates the striking out of this action. In the event that the defendant's application succeeds on this ground, the action will terminate and the alternative relief and arguments presented for and against its grant will not be considered. In the event that the application fails on that ground, the court will then proceed to determine whether, considering the circumstances of this case, it is proper to grant an order staying proceedings and referring parties to arbitration. The court will now proceed to consider these issues seriatim, having regard to the applicable law, the evidence adduced, and the arguments of counsel. Issue 1, the alleged non-compliance with pre-action protocol requirements. Arguing that Raspotech has failed to comply with the pre-action protocol requirements under the rules of this court and the relevant practice direction, Hesper urges this court to strike out this suit in accordance with Order 5, Rule 1, Sub Rule 3 of the rules of this court. In response, Raspotech contends that it has complied entirely with the pre-action protocol requirements and that the court ought to refuse the application. Raspotech submits further that, assuming without conceding that the allegation of non-compliance is proper, the proper order for the court to make is one referring the parties to settle and not striking out the suit. In its reply on points of law, Hesper emphasized the need for Raspotech in commencing its action to have complied with the specific stipulations of recovery of debt protocol, a specific protocol under the relevant practice direction, and states that this non-compliance is the basis of this application. Learned Defense Counsel has argued strenuously this morning that the claimant failed to disclose the entirety of its case because it did not disclose its claim for interest and for damages in its correspondence, and referred specifically to the prayers in the statement of claim. Now, I've considered the entirety of this application, and I find that Hesper's position is misconceived, because the provision in Order 501 on which this application is based relates specifically to front-loading requirements and not pre-action protocol. Now, the non-compliance with the resultant effect of nullity in that provision is with respect to front-loading of documents. Now, Raspotech has front-loaded all documents as required by the rules of court. Can it be said that the claim of the claimant is not fully disclosed, or that the claimant's claim is somehow beclouded to the defendant? I think not. All the documents, the correspondence, showed what the cause of action was. And it's the law that in commercial transactions, interest would automatically follow. So as a commercial entity and a commercial transaction, I do not believe that the defendant was in any way beclouded by the correspondence that was sent to it. Now, indeed, the expeditious disposal of civil causes, as the relevant practice direction, regulates compliance with pre-action protocol. And as seen in its pages 7 and 8 under failure of compliance with the protocol, I quote, when a party has not complied with the provisions of this protocol, the consequence is originating processes with supporting documents shall not be accepted for filing at the registry. The intent of the direction is clearly not to nullify the action. As such, there is no merit in the prayer to strike out this action. A review of Raspotech's pre-action protocol bundle reveals that parties extensively attempted settlement, including a settlement meeting, which held on the 16th of April 2020. Accordingly, the court is satisfied that Raspotech complied with the pre-action protocol requirements under the extant law, and the spirit of the practice direction, as set out in its preamble to which Leonard Silk referred, is clearly fulfilled, as evidenced by the contents of the bundle and other processes before this court. In the light of the following, the court hereby dismisses Harper's prayer for striking out of this suit. Furthermore, the court agrees with Raspotech's argument that even if it did not comply with the relevant practice direction, the appropriate order to suit. Accordingly, this prayer, the first prayer of this application, is refused. Issue 2, the prayer for stay of proceedings pending arbitration. The underlying agreement on which Raspotech claim is premised contains an arbitration clause, and Hesper has urged this court to refer the matter to arbitration and stay proceedings. Raspotech contends that, having filed a statement of defense, Hesper has taken a step in the proceedings, so it is not entitled to the prayer sought. Hesper replies with the interesting argument that this court ought to exercise its discretion and grant the application despite the step taken based on the intention of the drafters of the Lagos State Arbitration Law 2009, the LSAL of court, and the principles of international law in deciding this application. Learned counsel for the defendant has also argued this morning that the primary prayer of this application is based on an issue of jurisdiction and non-compliance, which must be raised in the defense, and that the application for stay is an alternative application and cannot be said to be a step in the proceedings, because all it does is to indicate that there should be arbitration. Well, as ASPA pointed out in its reply, the applicable law is the LSAL, not the Arbitration and Conciliation Act 1988. The arbitration agreement, as contained in Clause 11 of the underlying contract, does not contain a governing law. However, the arbitration being won within Lagos State is by operation of law governed by the LSAL. See Section 2 of the law. As rightly noted by ASPA, the considerations under both laws remain the same, and this is especially as Section 6 of the LSAL, which governs stay of proceedings, is a replica of Section 4 of the ACA, which provision has been considered by our courts in developing the principles under consideration. Now, the material facts of this application are not disputed. ASPA has filed a statement of defense and, as such, taken a step or submitted the first statement on the substance of the dispute under the applicable law. Accordingly, the question before this court is purely one of law, and that is whether the court ought to grant the present application, despite the effect of taking a step. The court notes that under our laws, the notion of taking a step is rooted in the contractual concept of waiver and the doctrine of estoppel. Essentially, courts have held that taking a step amounts to a waiver of the defendant's rights to compel the referral of the dispute to arbitration, and that having taken a step in the proceeding, the defendant is stopped from relying on arbitration agreement it had itself breached. See the case of Federal Ministry of Health and Lagos Nigeria Limited, reported in 2017 Law Pavilion Electronic Law Reports. Accordingly, this court holds that Hesper waived its right to refer the dispute to arbitration, having filed its defense. Also, the court rejects Hesper's argument that this court is mandated to refer the dispute to arbitration in accordance with the principles of international law, and dismisses its reliance on the case of Abacha and Fawenyi, reported in 2000 Law Pavilion Electronic Reports. Hesper's argument that the unilateral model law and New York Convention supports this argument for an automatic stay of proceedings is unfounded, as under our laws it trust that international instruments are only binding when ratified. See Section 12 of the Constitution of the Federal Republic of Nigeria. Furthermore, even assuming their applicability in original form, they remain model law instruments which are to be adopted and modified as the contracting states please. Accordingly, a reliance on a model law provision or the provision of a model law is unavailing. This court finds no support for Hesper's argument that it is mandated by Order 24 of the Rules of Court to file its defense before it can bring the present application. This argument ignores Order 24 Rule 2 Sub-Rule 3 of the Rules, which specifically caters for applications of this nature in providing that the abolition of the moral rule shall be, and I quote, without prejudice to the Arbitration Act or any other law under which a defendant must apply for stay of proceedings before filing a defense or other statement of case on the merits. To this extent, it is the considered view of this Honorable Court that there is no merit in Hesper's arguments under this issue. The Court has reviewed the processes before it, particularly the statement of defense, and notes that Hesper, in any case, failed to, as required by Order 24 of the Rules, raise the point of law that this action is premature or incompetent based on the arbitration clause in its statement of defense. Accordingly, even if the position of law as argued by Hesper was correct, it has failed to comply with the rules. So it cannot be said, as Senate Counsel has argued, that the sole purpose of the statement of defense was to comply with the rules to raise the issue, because the issue is not even in the statement of defense. Furthermore, the President's motion was filed on the 30th of April 2020, almost a week after the defense was filed. The court accordingly finds that at the time the defense was filed, Hesper's intention was not to uphold the arbitration agreement, but to submit to litigation. The prayer for stay represents a fresh proposal to arbitrate, which requires Raspotech's consent, but that is obviously missing, and as such, the prayer must fail. The prayer for stay is also hereby refused. This court accordingly holds that this application as a whole is lacking in merit. I'll take a moment to talk about the overriding objectives. The court has, in determining this application, considered the overriding objectives of civil procedure as contained in Order 2, Rule 1 of the rules and reproduced here below. The overriding objectives of these rules shall be as follows. A, to deal with every civil proceeding in ways that are proportionate, considering the nature and importance of the case, complexity of the issues, the amount of money involved, and the financial position of each party. B, to allot every civil proceeding an appropriate share of the court's resources while taking into account the need to allot resources to other cases. The overriding objectives are a legal mandate, not mere directions, which enjoin the court to interpret the rules and exercise its powers conferred in furtherance of them. The rules mandate the court to further the overriding objectives through active case management as defined under Rule 2 Sub-Rule 1C, Order 2 Sub-Rule 1C, which indicates mandating parties to settle, requiring compliance with pre-action protocol requirements, and giving directions for expeditious and efficient disposal of the suit, etc. Now, the striking out of this suit for an alleged non-compliance with the pre-action protocol as paid by the defendant does not further the overriding objectives stated above, because A, parties have engaged in extensive settlement before the commencement of this action, and 2, the nullification of this suit will lead to a loss of time and resources by the court and the parties. To grant the defendant's prayer will be to make directions without regard to the money at stake and the probable effect on the financial position of the parties. As for the prayer for stay pending arbitration, having analyzed the applicable law, it has no merit, and as such, there's no legal basis in this suit to further the objectives by mandating ADR. For all the above reasons, the prayers sought by the defendant are refused, and this application fails in its entirety. The defendant's application, dated the 30th of April 2020, is accordingly dismissed.
As the court pleases.
Because I'll be awarding the cost of this application. So I would like to hear some very brief costs.
Well, I will apply for costs to be awarded by the defendant, having had its application dismissed.
What are you asking for? Yes, Mr. Umezuke, how much are you asking for?
My Lord, I'll be asking for 50,000 Naira for the cost of this hearing.
Very well.
I would think it more prudent that we allow courts to be in the courts, given the pending trial. That would be my position.
As a matter of fact, I think the cost paid by the claimant is very magnanimous in the circumstances of this suit. And this is my order. Having found that there is overwhelming evidence to show compliance with the relevant practice direction, this court sees no basis for the defendant's challenge. Accordingly, cost of the sum of 50,000 Naira as paid by the claimant is ordered in the claimant's favor. Now, this ruling completes the case management conference, and this matter will now proceed to trial. The case is accordingly adjourned for trial.
Yes, madam. If I may have the liberty of making observations with regard to the trial that would commence tomorrow. And this is just indicates that by consent of parties, we have no objection to the admissibility of any of the documents which would be utilized for the trial tomorrow.
My Lord, that is the position. The parties have agreed that each and every document in the parties' list of documents will be admissible.
Let's register. Anyone?
Well, the courts will now rise. Courts rise. Thank you everyone for joining the proceedings today. We have noted the comments in the comment section. Sometimes people complain of poor audio, complain of poor network, but we're working on everything to make it perfect for tomorrow. I would invite your lordship to make final comments on proceedings today, if she so pleases, before we close. Thank you, lordship.
Thank you very much. This has been a good outing. There was very little interference from my own side. I heard everyone clearly. I don't know if people heard me clearly as well. But I'll make my closing remarks. Now, as I've noted in another, when I was given opportunity to comment once before, it appears to me that the COVID-19 caught the judicial system and legal practitioners napping, And although nobody could have predicted it, we would have been better prepared to the situation if we had paid adequate attention to ICT before now. So this situation has met us, and it can provide us an impetus to move forward if we decide, to use it positively. And I see that we've tried to rise to the occasion, but the most important thing is that we need a paradigm shift from the pedantic reasoning we've had for a long time to a proactive interpretation of our statutes. It's amazing that we're still arguing about the constitutionality of remote hearings, that whether it's public or it's not public. It's amazing in this day and age with the situation we have on our hands. And there was another mock proceeding, and I've read the ruling of Honorable Justice Peter O. Afen in that mock proceedings of Ogunwumiju, senior advocate, and Okutepa. And I agree with the reasoning. I don't think that there can be anything more public than a virtual hearing that can accommodate about 500 people. I don't think any of our courts will accommodate 500 people. So the argument that having a virtual hearing is not public is just, it cannot be right. So technology has come to stay, and we must embrace it. We must evolve and ensure that the administration of justice is not left behind in acquiring the great benefits of technological advancement. That one excuse of lack of infrastructure is not tenable, because Nigeria is more blessed than many of our neighbors who have already taken advantage of technology. So we just need to start with what we have and continue to develop. I remember someone sent me a picture of some courts, I think it was in Kenya, and they were practically sitting in the open on a stool, on some benches, and they had internet and were going on with proceedings. So we can't be talking of lack of infrastructure with all that we have. Of course, technological advancement will mean that we have to improve in many areas of justice delivery, and it won't be business as usual. And I think that our reference to technology now should not only be for the purpose of this pandemic. We must be able to apply it also to help efficiency, even after we've dealt with the pandemic. So hopefully, conduct of cases in courts will be a lot more efficient, and as a lot of the excuses for delay and adjournments will no longer be acceptable. Adjournments are the bane of legal practice, and we must get to the point where a date for hearing is a date, not a prelude to a definite date. As Counsel have fond of saying. Now, both the bench and the bar are guilty. We cannot say it's the bench or it's the bar. Both sides are guilty and need to shift their positions if we are to move forward. On the park bench, strict regime of costs and default fees is one way to communicate a policy of zero tolerance for delay, and striking out moribund and nuisance value cases should also be employed. The bar must look within and reorient its members to practice good case management. Continuing legal education will also play a role. There needs to be more active regulation of in order to set a standard. For me, this remote hearing has been a good experience for me. I know we migrate a knee-jerk reaction to challenges like COVID, a place where technology is employed beneficially for all proceedings for all times. Interestingly, Lagos State Judiciary had developed a mobile app for case tracking as far back as 2018, and I hope that project will move forward. And those are my few words. I'm very grateful to the Justice Reform Project for the invitation to participate in these proceedings. I admire the ideals of the organization and its overriding objectives, and I wish it every success. Thank you very much.
Thank you so much, Your Lordship, and thank everyone for joining today. Apart from showing that remote hearings are possible, we're also showing what counsel should sound like, how counsel should conduct the case and how judges should dispose of cases. We thank Your Lordship for our support and for delivering a ruling very quickly, despite even the changes that we did not anticipate. And we thank everybody for joining in. And tomorrow we will continue at trial, and we invite you to join us again. Thank you very much. It'll be a lot more complex with the tech, but we hope to get everything right tomorrow and to solve the problems we had today. Again, it's a learning experience, and we want everybody to join. We believe that the philosophy back at the Justice Reform Project, I speak for everybody and the people I work for, is that most of the business of courts can be conducted remotely. It's mostly motions, it's mostly things that do not need to happen in court. Apart from trials, which may be a little complex, everything else can be done remotely. And in times like this, and even going forward, to guarantee efficiency of court proceedings and administration of justice, we must look to tech, to ICT. So once again, thank you for joining in. We'll now end proceedings for today. See you same time and same place tomorrow.